So nice to have you here, and thank you for all my predecessors for giving me enough material to just add up what I want to say in a more technical way, because I was asked to present standards of accountability and independence of magistrates and attorneys in the jurisprudence of the European Court of Human Rights. So I wanted to add up to what probably Advocate General Michal Bauer would say. I wanted to make some distinction between the EU legal system and judicial system and European Court of Human Rights judicial system. And I just stressed out what are these particularities, specificities of the European Court of Human Rights judicial system. As you know, this is a supranational court where primary role lies with the contracting parties. As I said many times, margin of appreciation plays an important role in as well as with the right to independent judges as well. There are some limits to jurisprudential scope, for example, such as 14th and Green, and of course, contracting parties cannot avoid the scrutiny of the court in the field of conventional rights, and as you know, convention is a living instrument. Further on, there's no explicit reference to the independence of judges as a conventional right at the moment. However, the rule of law as a concept is mentioned in the preamble, and as you know, independence of judges is an inherent part of the rule of law. I would like to ask 4 questions. They're more like general ones. I am not strictly dealing with individual cases concerning the accountability, because I believe every decent judge or lawyer is able to decipher the logic behind the individual cases. So I would like to raise 4 more major issues which may give a broader picture how to understand the logic of the European Court of Human Rights in light of all these points of departure that I have already mentioned. The first question would be on the constitutional principle of separation of power, whether it is actually just judiciable before the European Court of Human Rights. The second question would be, to what extent the international standards of judicial independence and accountability impact the case law of the European Court of Human Rights? And more technically, how did the European Court of Human Rights set up on the basis of Article 6 of the Convention? And I will on purpose exclude other articles such as 8, 10, 14, 5, Article 1 of the Protocol 1, because at least partially we will deal this tomorrow on the freedom of expression concerning Article 10 issues. So how did the court set up the model of protection of the judiciary from unlawful external influence or even internal influence? And lastly, this is something that I started thinking more or less today, following the opinion of the very relevant Advocate General Michal Bauer in the case of the C55-20 as of today. So how to reconcile the latest development in some member states of the European Union with the principle of the equivalent protection as structured by the European Court of Human Rights in the Bosphorus line of cases. So these are my 4 questions. The first one is quite a simple one because it was answered already by the court. It is a general constitutional principle of separation of powers. However, it is not protected directly by the Convention, although the court recognizes the growing importance to the notion of separation of powers and the importance of safeguarding the independence of the judiciary, the very famous Baca case. However, on the other hand, the court says none of the provisions of the Convention require states to comply with any theoretical constitutional concepts. And so from these 2 lines of thought, the court concludes that, of course, for the independence of judges and judiciary, of course, the moment and the aftermath of the appointment is really substantively crucial. So the fact that the executive may play a role in the appointment of judges may not be per se contra the convention standards. However, if judges once appointed, they are free from influence or pressure when carrying out their adjudication. This is the standard. So this is the separation of power in practice of the human rights. Concerning the second question, to what extent individuals or even judges before the European Court of Human Rights may rely on the standards concerning independence of judges and accountability of judges in the national arena. So whether it's just a soft law, or we may find some more nuances or more power given to the standards by the jurisprudence of the court. Here you have a list, for example, of some of the references that the court made in the explanatory part of the judgment, several judgments, and you see that the court relies on many influences, such as UN standards, Council of Europe, internal Council of Europe standards, and of course even the standards of the professional groupings, such as Consultative Council of European Judges, and even they try to take influence from the comparative law, from the EU and of course Inter-American Court of Human Rights. But so far what we have seen, this is just a reference to it, but it actually in addition strengthens the general understanding that the rule of law is a precondition of the whole convention system, and of course that independence of judges as such is actually a building block of this logic. However, the court does not say that the independence of judges is actually a customary international law, as it was. This was mentioned in one of the separate opinions in the I believe in the very famous Icelandic case after Arvidsson. So systemic issues I would like to raise is just to mention them concern preconditions for the independence of judges. We are not talking about the individual case. We are talking about this. What are the preconditions, and they may relate, of course, to the issues of accountability if other powers in the specific nation or in the specific state actually interfere with the, for example, mode of appointment of the judges, interfere with the stability of the term of office of judges, the existence of guarantees against outside and inside pressures, and of course the appearance of independence that is actually a part of the general understanding of independence of judges. And of course, we've noticed that the court started to relate independence, impartiality, and the rule of law as an inseparable element. Of course, meaning that the appointment of judges actually may influence the consequences of an individual case. However, the whole standard, actually the main standard behind the whole practice of the European Court of Human Rights, is not related to the terms of such as independence, such as rule of law, but however the competence. I believe this relates to what Tomasz started in his introductory lecture today. The competence, which such as Bruno must inspire not only in the ranks of the judiciary, but in the public, in a democratic society. There's a strong relation, of course, between the rule of law and democracy. And of course, this is more individually related in the parties to the proceedings. In addition, the case law of the European Court of Human Rights strongly relates intentions of the legislator that have to be met by the adjudication system in relation to the rule of law, so that tribunals have to be established in conformity with the intentions of the, let's say, generally benevolent legislature. Governments may not rely on separation of legislation and any other provisions of domestic law in order to avoid scrutiny of the court. So the law, in the meaning of Article 6, paragraph 1 of the Convention, actually comprises any legal rule or measure within the member state that may impact the concept of independence of judges. And of course, the main standard, or one of the main standards, of course, judicial organization should not depend on the discretion of the executive. In terms of individual issues, this is something that already David talked about today. It's actually this systematic who may apply, who may raise issues of independence of judges before the court. It may be a party to proceedings or a judge concerned. On what it may be based, I already mentioned several articles that may be relevant. I will focus today only on the paragraph 1, article 6 of the Convention. And of course, what is the goal of this application? It is to protect the judiciary from several unlawful external or internal influence. I believe the main case in the field of having an applicant party to judicial proceedings would be Gudmundur Andri Assarsson versus Ireland, very famous Icelandic case, where the court actually established several, actually recalibrated several standards before what is considered as a tribunal established by the court in a very highly contentious case. If you read the concurring or dissenting, partially dissenting opinions of judges, you may see that there is a huge dissatisfaction with the logic behind this case, or even judiciability of this concrete case and results taken from this case in terms of the doctrine that the court applied in this case. So, but however, nevertheless, I would say this case is very much important for the independence of judges because it actually relates a notion of tribunal established by law and the conditions of independence and impartiality. And of course, that it confirms what was known in professional circles and in the, let's say, international standard, that it is inherent in the very notion of a tribunal that it is composed of judges elected on the basis of merit. And of course, that the process, as Thomas already mentioned, the process is relevant. The process necessarily constitutes an inherent element of the establishment of a court. These are some other interactions between the law, independence, and impartiality. The court emphasizes not only personal independence of a judge, but also institutional independence at the initial stage of an appointment of a judge, starting there and of course later on during the service. Yeah, one of the relevant cases actually relates to the effect of this judgment. To what extent may such judgment, finding of a violation, actually play a role in restitution of a, let's say, a restitution in integrum, whether it is possible to reinstate a situation before the breach actually happened in national environment. And the court, of course, sees the problem with two major legal principles, such as res judicata and the principle of irremovability of judges, and how to make let's say, a consistent and coherent compromise between these partly excluding principles, and the court strives for a balancing approach and allows a certain margin of appreciation for national authorities, and establishes three-pronged test, which is a bit more stringent than just flagrant breach that was presented by the chamber judgment. As you know, the Icelandic case ended in the Grand Chamber judgment, and the standard is much more nuanced. However, I find it problematic from the viewpoint that in practice it may allow too much of a leeway for national authorities, and by doing so, the court itself diminishes the practical importance of the judgment, in particular with those states that are, in a way, not so, let's say, honest. They're not acting in a good faith, as we already have some experience by now. So the other part of my presentation would be when a judge is acting as an applicant before the court. I believe the leading case in this case is very famous, Baca versus Hungary. Still, I believe all other cases are continuing this very logic. But I believe that we may expect some of the development in the Polish saga of cases, which I will talk about a little bit later. So what we have seen here, Baca was very important in coining civil limb of the Article 6 by equating civil servants and judges in order to understand that the rights of a judge may be understood as civil rights, by a little bit expanding with the Vilho, Eskin, and other line of cases. However, we know that in principle presumption that Article 2 applies, member state contracting parties have two exceptions to fulfill in order to be exempt from the Article 6 adjudication. And they are quite stringent, so I believe in practice it will be really hard for contracting states to avoid judicial review by the European Court of Human Rights, because the constitutional standard would actually not allow such an exception in practice. Finally, for the comparison between judges and public prosecutors and attorneys, I would say in principle, same protection applies as the one provided for judges, while taking into account several specificities for public prosecutors and attorneys. Concerning the legal effect of the judgments of the European Court of Human Rights, we all know they are in principle declaratory. However, there are some attempts to overcome Article 6 deficiencies. For example, in the case of Alexander Volkov, there was an instruction to restate the judge, which I find very promising. However, at the end, it all summarizes down to the good faith of a specific state. As I already mentioned, there's a lot of balancing between several principles. The issue that I see as problematic is non-recognition of the binding nature of the European Court of Human Rights judgments. For example, in the last few days we have read, I haven't been totally informed what was going on, but I read some comments that the Polish authorities declared the judgment in the ECtHR versus Poland as ultra vires, which is in a way quite problematic stance by national authorities, especially by declaring this unilaterally. And of course, the general issue of practical meaning of the judgments to the disobedient contracting state. By, for example, that the state of course does not want to implement the judgment as a follow-up to the standards that the European Court of Human Rights apply. So the fourth question I would like to raise is, as of today, the issue that, as we know, that the European Court of Human Rights applied for the member states of the European Union a specific principle of equivalent protection through Bosphorus saga, and by this, of course, the European Court of Human Rights is more reserved to engage in the substantive review of individual cases where contracting states of the European Convention of Human Rights were actually fulfilling obligations from the European Union legislation. And the standard itself is rebuttable. It's a principle of equivalent protection that may be rebutted by expressing, by reasoning manifestly deficient legislative setting or executive setting of the EU judicial system and legal standards. And I get the idea that it might be a problem now. From now, at least we have to raise this as an issue. I got the idea from the opinion of Advocate General Michal Bobek issued today, that because he expresses some concerns, the preliminary ruling mechanism, that it's not ideal in specific cases, and it actually relates to the specific cases of protection of rule of law within the European Union. And what we have seen, of course, Advocate General emphasizes varying practical value of available legal mechanism in highly contested disputes. And he declares references for a preliminary ruling might not be ideal for dealing with, let's say, specific opposing member states of the European Union in highly contested disputes. He believes that infringement actions are much more relevant and appropriate. However, what I see from the perspective of the European Court of Human Rights judicial system, of course, infringement actions do not allow individual applicants to dictate, to influence the European Commission or other member states, individuals do not have any practical possibility to influence it. And if reference for a preliminary ruling are not ideal, this may play part in understanding whether the mechanism provided by EU law for supervising observance of fundamental rights, insofar as its full potential has been deployed, still be considered equivalent to the one of the European Convention on Human Rights. We all know that there's a really more or less impossible legal pathway for individuals to access the Court of Justice of the European Union directly. And references for a preliminary ruling were considered by the European Court of Human Rights as, let's say, at least comparable procedural pathway for an individual. And for this reason, the court in Strasbourg claimed there is a presumption of equivalence in the procedural terms. I'm not sure whether this would be possible in this line of cases that deal with the rule of law and independence of judges anymore. At least I'm opening up this debate from now on. Finally, and I will conclude with this, is I'm just raising other potential future possibilities or alternatives, how one may further strengthen individual right to independence of a judge, or systemic principle of rule of law and independence of judges before the court, by making a comparison with the individual application, typical individual application. I'm raising three groups. The first one relates to procedural step, the second one to legal effects, and the third one substantive claims. What we have seen, some of these approaches have been already employed by attorneys in Polish cases, for example, strategic litigation, claiming Article 18 in conjunction with other conventional rights. And of course, we may expect at one point probably pilot judgments because of systemic deficiencies made by the court. I don't want to take any more of your precious time, so I will probably stop here. Thank you very much.